So your doctor says you're all healed up, as good as you're going to get, and he gives you a very low impairment rating for an injury to an extremity. That's the situation we're talking about today. Hi, I'm Kevin Runlet with Runlet Law Firm. We represent injured workers in the state of Mississippi. These videos are to hopefully provide you with some valuable information if you have a claim or if a loved one has a claim, and I really do hope they help. So what happens if your doctor says, okay, you had an injury to your hand, maybe you lost a finger, you have reached maximum medical improvement, and the doctor gives you a really low impairment rating. Why does that matter? Well, the impairment rating with a scheduled member injury, which is an injury to any body part that you don't have to survive, hand, leg, foot, fingers, those kind of things. If they give you a low impairment rating, the question becomes, okay, is that all you can get, a settlement based upon what the doctor has said? Because that is very important to the computation of what the settlement should be. And the answer to that is no, and we have a way to combat that situation. And really it is an element of the law that is developed within workers' comp, because they understand that that impairment rating that the doctor gave you, that's what we call anatomical. They're going to look at your injury, maybe look at what your functional capacity examination said, and they're going to go to a book, and they're going to look in that book, and there is a standard rating without knowing your exact circumstances that's based on your anatomy, the human anatomy, and it's very general. And that's the impairment rating that that doctor's going to give you. So how does that translate? Let's say he gave you a 3% impairment rating to your hand. You use your hands exclusively in your job, and now you can't do that. How does that work? It's not fair, right? Well, the law is compensated for this, and we can come in and we can argue what is called loss of industrial use of that hand. So really, an anatomical rating of 5% impairment is probably going to translate much more than that with a loss of use argument. If we say he can't do any part of his job, we can argue it's 100% loss of use of your hand, because it prevents you from doing the job that you previously did. And it's that simple. Now, it sounds simple. We do have some things that we have to prove when that's the situation, and we will do that. So hopefully this helps you understand a little bit more about that impairment rating. Remember, there's kind of two types. The doctor's going to give you an anatomical rating, but really your claim is based more on what that loss of industrial use is. How has that prevented you from doing your job? I hope these help. Hit the subscribe button. Send us any comments or questions that you have. We're happy to hear your story, and I appreciate you watching.